Our next case is MSSC versus Airboss. This is also a 20-minute grant. Welcome, counsel. You may reserve some of your time if we do not use it up, and please do your best to keep track of your time, and you have 2 minutes of a free fire zone if you wish.
Good morning, Chief Justice, and may it please the court. My name is Gaten Gervillariash, and I represent appellant Airboss Flexible Products. I intend to reserve.
Just 1 second, yeah. Wait for the doors to close. Okay, sorry about that. Please proceed.
I intend to reserve at least 5 minutes of my time for rebuttal.
Okay.
Now, the question in this appeal is whether a blanket purchase order satisfies the UCC's statute of frauds when it specifies no quantity but says that the buyer will issue or send other documents later called releases for yet unknown quantities. And the answer to that is no, for the simple reason that the UCC explicitly prohibits the enforcement of any quantity beyond the quantity shown in the writing. Now, the legislature, the code here, uses a definite Article V indicating that there has to be a specific quantity, and it says that the writing must show what that quantity is. So as this court did say in Lorenz, what that means is the quantity must be specifically stated in the writing. And the purpose of this rule is to give the courts and the parties clarity and certainty as to when they've entered into an enforceable contract and what the scope of that contract is. Satisfying that rule is not hard. If MSSC had really wanted a requirements contract, they could have easily said so in the blanket purchase order that they issued. They could have said something like, this purchase order is for 100% of MSSC's requirements. Or the buyer agrees to purchase all parts that it needs for the program. Or even the part is 100% sourced to seller for the life of the program, language that we gave them that they refused to put into the writing. Forcing purchasers to say these things in writing is not going to bring the industry to a grinding halt. They've known how to do this for decades, as reflected in the case law examples we've given, showing where they have done it. And if they don't do it—
When was the contract actually formed in this case? When do we have a contract?
When they send a release with a specific quantity and Airboss accepts that release. That is when they have an enforceable contract, and at that point, all the terms in the blanket purchase order apply to that quantity of goods.
So do we have serial contracts with each release?
Yes, you have serial contracts with each release. And all they've done with this blanket purchase order is negotiate in advance some of the essential terms of the contract except for the quantity. And they've left the quantity to the releases. So until they send a release with a quantity, there's no contract for sale. And there's been no offer that has been accepted by Airboss. And so the only quantities that are enforceable under this writing are those that are reflected in the releases, which with that writing and this one combined. Now, the reason those releases are not in the record here is because those aren't the quantities that MSSC wants to enforce here. They want to enforce a quantity that is not shown in any of the writings, and that is their requirements. What doesn't satisfy the statute of frauds are non-committal statements like we have here. Statements like any amount from 0 to 100% requirements, or for quantities to be indicated in our future releases, or as in our case, the buyer shall issue a vendor release and shipping schedule. There's no objective measure in any of those statements for an amount of goods. The buyer is left to order whatever they want, whenever they want it.
Do they have to issue a release? Are they obligated?
So the
To do
language
that?
said shall issue a release, and vendor release and shipping schedule.
So
But
at
they
least
were
one.
entitled to cancel it whenever they wanted. They reserved that right to cancel any releases they sent. So if they wanted to fully perform their obligations without ordering a single part, all they had to do was send a vendor release and shipping schedule and then cancel it.
Could
We're
they
done.
get it from somebody else?
Yes, absolutely, because it's not a requirements contract. In a requirements contract, they can't order from anyone else. That's why requirements are considered to be a specific quantity.
So
You
what is-
order
what
one
is-
part.
What is the point of it then? Like, I mean, if these contracts aren't formed until it's requirement, they don't even have to issue them, they're not even, it doesn't even, obligate them to only work with this one particular vendor, what's the point of it?
Well, the point is to come to some terms ahead of time and perhaps enter into a relationship where they will, every time a release comes, Airboss knows what the terms and conditions are that come with that release, and they're not renegotiating those. Now, they can, if they don't want to accept that quantity and they don't want to accept those terms at any point in time, they can do that. They can simply not accept. On the flip side, MSSC can send out releases for firm releases for quantities months in advance and give Airboss notice, and Airboss, when they get that release, if they don't object within 10 days, that becomes that could become a binding contract on them. Now, I think that there's a provision between merchants and the UCC, and it says that when you don't object, you've satisfied the signature requirement. So I think all that means basically is that you've satisfied the statute of frauds. It doesn't necessarily mean that it's been accepted. But woe be it to merchants who don't object when they get an order like that, particularly in these circumstances where you have a blanket purchase order. And if Airboss doesn't object but remains silent, MSSC could say, hey, are you going to accept these 4 months of orders where we've laid out a shipping schedule or not? Because if you're not, we got to move on to somebody else and have someone else supply these.
Counsel, is there ever a time where using the term blanket could be considered a quantity term, or is it just always never a quantity term?
If they define it as that. I mean, we had specific definitions here. Sure, you can call it a tomato contract and define it. Tomato, if I call this a tomato contract, it means I'm ordering my requirements. But that's not what they said. In fact, what they said was, all that means is we're issuing a vendor release and shipping schedule, and we can cancel that if we want to. So basically, we don't have any obligation.
So the key to you is it didn't specify a quantity, plus they could just exit any time.
Yes, it's not even an exit. We don't have a contract yet. There's nothing to exit. It was a serious mistake here to infer, and this is what the lower courts basically did. They inferred that essentially any time a buyer is going to send releases, that they're always going to buy their requirements. Well, what if they want to enter into an engagement with multiple vendors, and they're using releases for all of them? Have they entered into requirements contracts with all of them? Now they've breached with every single vendor because they haven't ordered all their requirements from each vendor, which would obviously be impossible? Of course not. There's an enormous difference between promising up front that you are going to purchase your requirements and you're going to inform the seller what those are as they arise through the releases, and simply saying, we'll issue releases for quantities when we know what they are, leaving it open to order whatever you want. I think that the amicus brief in this case laid it out with admirable clarity. I would liken it to the difference between basically dating and being married. People, when they date...
We don't want to go there. The amicus, similarly situated to you, tells us, I think, or encourages us to do away with Great Northern Packaging, Cadillac Rubber Disavow, Johnson Controls. I mean, just an overhaul here of our case law. For you to prevail, do we have to do that?
No.
How do we get there?
Because
How do
So-
we make sense of all these other cases that the amici don't like?
What happened in Great Northern is the court thought that there was a term, that the term blanket in that contract, because of the circumstances in which that term had arisen in the contract, was ambiguous as to what quantity, if any, that stated. And therefore thought that parole evidence should be allowed to determine what the quantity was, whether it was a requirements contract or not, and so it let the jury decide that question. We don't have anything like that here. We have a contract, we have a blanket purchase order that says, all we're gonna do, it defines blanket. So you don't get to look outside of the writing here and say, well, it means something different than what they defined it, or something more. They decided they were gonna tell us exactly what it said, what it means. And all it meant was we're gonna issue a vendor release and shipping schedule. That's it. And that doesn't state any quantity whatsoever. Now, I don't think Great Northern is correct. I do think it is absolutely wrong, because how can you say the writing shows the quantity if when you look at the writing, you don't know what the quantity is? That's not the writing, the quantity shown in the writing. It's not shown in the writing if you have to look elsewhere to discern the quantity. So I think Great Northern, frankly, should be overturned, because it's just too slippery of a slope to stand on. If you adopt a rule where anytime if it's ambiguous, we can look at parole evidence, then all you're doing is essentially nullifying the second requirement, right? The parties, anytime they don't really want the statute of frauds to govern, they can just put in an ambiguous term, and then they get to go into court whenever they want, and whenever they have a dispute that arises. And basically, all you're applying is the first term of the statute of frauds, which says there has to be writing sufficient to indicate that a contract for sale has been made. But there's two requirements here. It has to indicate a contract for sale has been made, and that, of course, means there has to be some indication you're buying a quantity. But it also says that quantity has to be shown in the writing. So I don't think I think Great Northern basically nullifies the second requirement in the statute of frauds. And as for Cadillac Rubber, the court, that's not a requirements contract when all you've agreed upon is that you'll buy a minimum of one part. You have not committed. You've not committed to buying your requirements. And with no commitment, there's no contract. Now, they had a contract in that case, different from ours, for one part, pursuant to that purchase order, but they didn't have a requirements contract because they didn't agree to buy their requirements. So I do think Cadillac Rubber is incorrect as well. And this doesn't mean throwing out all of the case law, because this court laid down what the rule was in Lorenz, and the lower courts simply didn't follow it. I think all the court has to do is reaffirm Lorenz and say those other cases are inconsistent with what this court said in that case. The writing here simply does not show that there's a quantity. Instead, it shows MSSC did not want to commit. They did not want to commit to Airboss. They didn't want to be married. Okay? And if you're not married, it doesn't matter if you had a long-term relationship and you invested a lot into it and it lasted for so long. You don't get to hail someone into court for a divorce proceeding and claim half the assets and alimony if you weren't going to commit to marriage. It was only later, frankly, that MSSC concluded this arrangement, this flexible arrangement they had, wasn't to their advantage. And so that's when they came in and said, well, you know, we want you to enforce an arrangement that we didn't actually agree to in writing, that they in fact declined to agree to in writing. And the statute of frauds was intended to prevent exactly these sort of shenanigans. By allowing it to happen in this case, the lower courts have created tremendous uncertainty as to when parties have entered into an enforceable requirements contract. And for that reason, we ask that the court reverse. Unless there are any further questions, I'll reserve the remainder of my time for rebuttal.
Thank you.
Good morning, Justices. Mike Latif on behalf of MSSC Inc., the appellee in this case. I'd like to kind of jump right into the question which you've asked for us to address, which is, does 2201 confirm a contract here? And when was the contract formed, Justice Zara, to your question? It was formed in 2013. It was formed when the parties agreed on a blanket purchase order. There's no dispute, I don't think counsel now disputes that this is a blanket purchase order. And what does blanket mean? All-encompassing purchase order. Why do I say that the contract is formed? What was the obligation on MSSC? They want to skip over the notion of what blanket means and how it's defined and just go to, well, it just means releases. No, I don't think that's what it means. What it means is, if this is a blanket order, and this is what it says, if this is a blanket order, and we have no dispute that it is, then buyer shall issue releases for the specific parts, provisions, quantities, and delivery dates for products. When you marry that with the purchase order detail that says, we don't know how much our customer, in this case FCA, Stellantis, Chrysler, is going to order, then that's the basis. We will order, every order that we get from our customer will have to go to you. It shall go to you. It's an imperative. We have no choice. And we did. We did that for 7 years. We didn't buy from anywhere else. We shipped them. Now what they want to do is, when the circumstances change and they don't like the contract anymore, is come in and say, well, we never really had a contract. All this was a series of releases that we never told you we weren't accepting or not accepting. That's all it was. And there was never a contract formed. Well, the only contracts formed were when we sent a release and we shipped to you. Well, that's not what happened here. That's not what happened in Lorenz. And we can talk about Lorenz in a minute, but essentially that case didn't even deal with this type of contract, not an output.
Counsel, but didn't the behavior, I agree, one interpretation of the party's conduct could be what you're saying, but couldn't it also show a release by release contract over 7 years?
I don't believe it can. And I don't believe it can because the imperative that exists and the requirements of the imperative that exists in the word shall. We had no choice. We had to ship to them. And we did it for the quantities that were requested from at the prices that they agreed to in the blanket purchase order.
But you could have stopped any time, correct?
No, we couldn't have. If we had stopped, let's use that example just as well. Let's assume for a minute, shoe was on the other foot. And let's assume Airboss was making 200% profit on every part that they made to us. And this was the greatest part contract they had. And we decided, hey, we want to make more money. We're going to go find an alternate source, and we're going to go sell to them. They would be in here arguing that shall imperative means we have a requirements contract, and you have to order from us because we want our 200% profit on every part. The exact opposite would be true. What they're essentially doing in this argument is shifting the burden that exists under 2.306, comment 2, an outputs contract, where it says the seller assumes the risk, right? The seller assumes the risk. Well, you might not buy any. And if an epidemic happens and our customer shuts down their factory and has no orders from us, then yeah, we may not be able to order any products from you. And that becomes zero. That's an assumed risk of seller. What they're trying to do here is ask this court to shift that burden from sellers to buyers. Because now everything is a release contract, and they can reject everything and say, you know what, we want 500% above the part price on this one. We'll ship it to you if you pay us that much, which is essentially what they were trying to do. I used the 500%, but I think theirs was approximately 200% increase in this particular case that they wanted us to agree to, or they weren't going to ship. So what in effect is happening here is the industry, the supplier-based industry, is trying to ask this court to shift the burden of the assumption of risk from a buyer, or from a seller, to the buyer. And that I think would propose all kinds of problems. Currently in the system, in the supply chain, there's just-in-time, as you all know. There's a production part approval process, the PPAP. We're not at liberty to go, as Brother Counsel said, go buy from somebody else in 4 months or 2 months, or 6 months, because we have to have our customer, Chrysler, approve any alternative source other than Airboss if we're going to use an alternative source. And that time frame to do that is anywhere from 12 to 18 months for a safety critical part like these are. These are stabilizer rods that go into your car that control the suspension. You can't just go to the next guy or the next company or the next person and buy that product. Chrysler has to review it, they have to approve it, they have to say, okay, we're okay with this part, we've tested it, and it's okay. And that's what happens in this industry. So how has the supply base dealt with that? And how have they dealt with these uncertain, unprecise, I should say, imprecise amounts of quantities? Well, they've negotiated around it. They've said, if raw material prices increase, then we get the pass-through increase on price, so that we're not at a position of being leveraged. Even in this case, when they came to us with a price increase request, we tried to pass it through to our OEM. And the OEM said, no, we can't. And at that point, we have a contract. Again, what they're trying to do is shift the burden, but they're also trying to ask this court to remove the ability to have an imprecise quantity.
So, to use Brother Counselor's analogy, he said the parties here were not married. They were dating, basically. You think they were married? Were they
For
were
10 years,
attached?
For
and
7 years,
They couldn't?
and then some.
Okay.
Yes.
What do we do about Lorenz? Do you think that Lorenz has been abandoned by the Court of Appeals?
No. I think Lorenz, first of all, it didn't deal with an output contract, and second, the majority holding was, this wasn't governed, their contract, the distributor agreement, wasn't governed by the UCC. This was they determined that the whole contract is outside the scope of the UCC. So they didn't really address, I know as much as they want to put emphasis, and the appellants want to put emphasis on Lorenz, I don't think Lorenz is the guiding principle here. Great Northern is. I think Judge Zatkoff's discussion of the varying laws throughout his opinion in the JCI case is very instructive. I think to dismiss it as him being misled is a mistake. I think Justice Zatkoff did a very thorough analysis of both sides of this equation, and he came down on the premise that in order to promote what the UCC wants to do, then the best reading of this is to adopt Great Northern and to say, hey, you can have a quantity and it can be imprecise. And then we go back to the court if we need to look at what is that quantity? What did you mean by the quantity? What's the question of fact? We don't have the need to go back in this court because the only facts before the court Judge Alexander were, the president of the company saying we want 100% of the requirements. We agreeing we're going to give you 100% of the requirements. There was a course of performance over 8 years of what we had done. So there was no evidence to suggest that the parties had anything other than an outputs requirements contract. There was not a single piece of evidence submitted by, in that case, the defendant or the appellants to suggest otherwise. So it would be a severe injustice in this case to say, oh no, we didn't have that. We had a release by release contract.
To understand the meaning of blanket, can parole evidence be admitted in the lower courts?
It can be as as Judge Alexander determined, he said, I've determined by the term blanket in the review of the definition that there is an imprecise quantity confirmed here. Now, based on that, and based on In re Frost, I can explore parole evidence. And the parole evidence he summarized in his opinion was all the things I just said, saying there's no dispute here.
Should I be confused or held back by the notion that the releases have specific quantities, and that seems to be somewhat inconsistent with the requirements contract?
No, I don't think you should be, because it doesn't, a release does have a quantity, because a quantity can't be known until the customer tells us how much they need. At that point, we now know we can issue a release and we can get that product. Before then, it's an unknown, and that's what 2306 stands for. That's the purpose of it. And if you accept their principle, 2306, in my mind, is eviscerated. It means nothing. You're giving no meaning to that anymore, because now the fact that we have unknown, we can't have that anymore according to their interpretation. We have to have a percentage, a numeric number. It can't be imprecise. It has to be precise, and therefore you do have to, I would think, to answer a question that was asked, I think Justice Zara, you asked the question, do we have to get rid of Great Northern? Do we have to get rid of all these cases? You would. You absolutely would. And back to the Lorenz for a minute, I don't think the majority dealt with this issue. I think they said, in my reading, but we're not going to deal with it because this falls outside the UCC. However, Justice Brickley did a nice concurring opinion. I'm a little candidly flummoxed on how it's concurring because I think his ultimate conclusion is, I find that the UCC does apply, and I find that it is a requirements contract, and I find that there was a quantity, albeit imprecise, that was stated in this agreement, this distribution agreement. And remember, that distribution agreement was a letter that said, welcome to our association. Well, you're a distributor now for American Standard. That's all it said.
Counsel, I have a question, and again, I always ask more like simple questions, but I like to always understand the long-term ramifications of what this court does. If we were to adopt Brother Counsel's position on this, what would the effect be on the industry, if any?
The effect would be, Justice Bernstein, what I attempted to convey, the shifting of the burden of the assumption of risk from what is now the seller to now the buyer. So in other words, the OEM, the tier one who's buying, because now you're in a leveraged position. Unless you make your contract specific as to 100% requirement, as their counseling, now you're going to say, well, I need this release. And if they don't like the economics of it, they can say, well, I'm not giving you that release unless you pay me 2 times, 3 times, 4 times, 10 times the price for that part, right? And by the way, I know you can't get it anywhere else because it'll take you 12 to 18 months to go get that safety critical card approved by your client. So I've got you. Pay my number. That's the problem. And like I said, these suppliers and the amici suppliers that submitted, they're sophisticated users, as is MSSC, as is Airboss. They're sophisticated folks who deal in this all the time. And they found ways to deal with the economics, even in an outputs requirement contract, by using commodity base for raw materials to shift up and down as the prices increase or decrease, as oil prices increase or decreases, their raw materials prices go up. And it's a fair commitment to do that. But they found ways around that.
What about, Amici makes the point, I believe it was Amici, that Michigan is essentially an outlier now on how we're interpreting these blanket provisions. Do you disagree with that?
Can you say that? I didn't hear the one part.
That they're an outlier, that Michigan law now is not consistent with how other states are interpreting this?
Well, I think, first of all, Michigan law has been consistent for the better part of 35 years on this, and that the industry knows how to deal with this and has responded to it. And I think the suggestion that we're an outlier, that the chaos will ensue if you don't do what they ask, is complete misnomer and a red herring. I think the status quo is working quite well. Yes, are there cases that upon occasion a certain terminology or certain provision within a contract becomes a dispute and you have to come to a court? Yes, but on average, these contracts are, just as they're written in this case by MSC, are constants throughout the industry. And it's how the industry operates. And everybody understands what this means, and they clearly understand. I mean, again, you look at the evidence there, their president demanded 100% of the requirements, and we agreed to it, and we lived up to it, and we provided them 100% of the requirements throughout. There's no question.
I don't want to ask the inane question that could be asked in any contract case about why you didn't use more specific language in the contract to avoid this court dispute. So I'll try to come at it a little different way and ask you, what are you relying on? Is it the language of the contract or a course of dealings to establish that this was a requirements contract, or some combination of the two? Could you just be, is it just the fact that it says you shall issue the releases, or is it something else?
First, I think it's the issue that it says shall is sufficient to satisfy that this is a contract and it's for an imprecise quantity. Second,
Without a quantity.
well,
They
it
could
does have
issue
it.
a release, they could issue a release that says you shall produce nothing. We don't need anything. And that would satisfy that.
Within the confines of good faith, there's always, to answer your question more fully, there's always the contents of good faith within a contract that has to be bought, but that's implicit. But expressly under 2306, it's explicit in that you have to operate within good faith. And so they're not free to just order, as they say, 0 to infinity. You can't. That's not allowed under this contract or under the law, because we have to operate within good faith requirement.
Well, that kind of is a little bit of a circular argument, right? That assumes that it's a requirements contract. The question is, how do we know that it's a requirements contract and not a release by release relationship?
Again, because, and my answer to that, Justice Viviano, is because the obligation and the commitment is stated within there, it's defined as we shall. Number one, we shall issue these releases, and you marry that with the purchase order that says, we do not know the specific languages under the special instructions. It's multiple places within the purchase order, but the easiest is page 7 of the purchase order, the special instruction. Volume is an estimate based on a forecast provided by the OEM and cannot be guaranteed. So they know full well going in, when we make this contract and we make this agreement, that we're relying on the OEM, they're relying on us. That's the way this business works. But once we get a volume from the OEM, we must.
How much of
issue
your, let me ask more specifically, how much of your argument depends on course of dealing? I mean, I assume what happens here is that when these programs are embarked upon, and you enter into a relationship with your, the next tier supplier, they have to go make investments in tooling and do certain things. They're not just sort of waiting around. And I think you mentioned course of dealings. How much of your argument is based on what is it, you said 7 years this program has been in effect?
Yes.
How much of your argument is based on that?
I think I have two alternative arguments, to be clear. I think the first is that a contract is established based on the face of the documents without going to what the parole evidence would say on that point. But the second one is, I think there's sufficient amount, even if you would disagree with that will as an obligation, I think there's enough in this contract to specify an imprecise quantity, as Judge Alexander found, and as the Court of Appeals found, and as Great Northern has found, to say, okay, now we can look at the additional parole evidence and see what was the deal. And it was clearly a deal. I mean, I don't think anybody disputes what the parole evidence says in this case as to what the deal was. I mean, it's very...
What's your response to counsel's point or allegation that they came to you and asked you to put in the precise language that would fit in this, this relationship under 2306, and your client rejected that language?
I disagree. And if you read the evidence, that's not what it says, and it's not what there was an email that says we want awarded the bushings and bonding. That's what their president said. We wrote back and saying you will get 100% of those requirements. And the response back was, sounds good to me. The email's in the evidence, that's what it says. And we issued a purchase order the next day that said, hey, you're getting these parts, right? And so that was the confirmation of it. I mean, there's no dispute, and they have. There's no evidence to suggest we ever went somewhere else and sell, and we can't. And the notion that we could make it ourselves, that was speculated in there. It's just speculation. There's no basis. There's no evidence to suggest we can. We have not sought to get production part approval from Chrysler to make it ourselves.
Well, what about the part that in defining blanket orders, it says, yes, you shall issue a release, but with specific quantities, and you shall have the right to cancel, adjust, or reschedule the quantities. I mean, at your discretion, at your disposal, what quantity, if you say, yes, we'll issue a release that says the quantities, we also can change it or adjust it or cancel it at our discretion. So what quantity are you committing yourselves to?
Well, we're committing ourselves unless it's a firm, there's some exceptional language in there.
Yeah, I mean, but unless it's a firm obligation, right, which you get to decide, I think also, or you get to name it as a firm obligation. But what quantity, like what is, I get it's defined in we're looking at the language of the contract. It says you shall issue the release that specifies the quantity, but we can also adjust, cancel,
right,
whatever
so
those quantities are.
Whatever the quantities are, and the reason that adjustment's in there is because if our customer adjusts, we adjust, right? I mean, that's the basis and reason for it. You have to be, if volumes change, if they want to build a part bank, if they want to go up.
It says the right to cancel the quantities too.
Right.
So like you could order nothing.
If Chrysler was to send us and say, we're canceling our orders to you, MSSC, then we have the right to say, hey, we're canceling, unless it's a firm obligation, of course. But you're accepting that, I get that. But that's the point, and that's the reason it's in there. And there's still the good faith requirement inherent both in 2306 and implicit in all contracts. So it's not unfettered. It isn't 0 to infinity, as appellants want to suggest. We don't have that ability. See, my time's up here, but I'm happy to answer any other questions if you like. I just want to add in real quickly, we do have an independent basis beyond all of this, that this case should be affirmed at the lower court, and that is the letter agreement. I won't belabor that, but we gave consideration of $300,000+ that we didn't have to give and that we're not committed to in exchange for their agreement not to come to us and ask for an increase in price. And not 2 months after the ink was barely dry, they came back to us and asked for an increase in price. And Judge Alexander found an independent basis on which to rely to determine that we were entitled to summary judgment. So regardless of what you do in the principal issue for the court, I still think the case should be affirmed on the independent basis that we had a separate contract that we agreed to that they violated.
Thank you.
I hate to say this, but there were so many extra record statements in that and inaccuracies that it's really going to be hard for me to get through them in 5 minutes. First of all, the statement that the justice in Lorenz, who supposedly concurred, found that there was a specific term in the writing is absolutely wrong. The majority rejected the concurrence because the concurring opinion was inferring that this should have been a requirements contract, that that's what the parties wanted, which is exactly what the Court of Appeals did in this case, and which is why this court should, in reaffirming Lorenz, would have to reverse the Court of Appeals. Secondly, the question was made about, course of dealing and whether they're relying on that. Obviously, they said they have two different arguments, but you can't make a contract through course of dealing. The course of dealing is an interpretive tool for interpreting a contract that already exists. It doesn't make a contract. If I buy all my meat from Meijer, I don't suddenly fall into a requirements contract with Meijer or vice versa. I've just decided that that's what I want to do, but I've not committed, and neither have they, that I'm going to always get my meat. So when I show up and they don't have the rump roast for me, I don't get to sue them because they breached the terms of a requirements contract based on some course of dealing that I had with Meijer. Now, as far as the bushings and bindings are concerned, that's not the language that we were dealing with. What we have here is we have what they're trying to do basically is tie the requirements to the releases without saying so in the writing. And if this court adopts a position that every time a party uses releases, they have entered into a requirements contract, what you're creating is a situation where every time a party wants to use this construct for its arrangement and have a blanket purchase order and releases, it's going to have to say, this is not a requirements contract. And then when that expires and they issue another blanket purchase order, they're going to have to, again, make sure that phrase is in there, this is not a requirements contract. And it's going to be a game of gotcha where in the 10th iteration, when somehow this falls off the page and they no longer have the phrase, this is not a requirements, oh, you intended a requirements contract. That's not how contract law works. People say what they want. We don't force them into a default rule, whether it's the automotive industry or anyone else, that, well, it's really good for you to just enter into requirements contracts in this context, so we're just going to presume that every contract you enter is a requirements contract unless you say otherwise. That's basically the rule that we're winding up with here. It is perfectly acceptable, and parties should have the option to use a blanket purchase order and say what they want in terms of quantities through releases without being forced to enter into a contract that's not what they wanted, a requirements contract inadvertently, or have to say this is not a requirements contract.
Could you kindly respond to Brother Counsel's argument that if the court were to adopt your position, it's going to shift the burden and it's going to basically transform the way that the industry kind of handles these issues and handles these types of relationships?
You know what the answer, Justice Bernstein, is? That they don't want that burden? Put it in the contract. write it down, commit in writing. It's that simple. It is not going to bring the industry to its knees. They can say what they want in the writing. If they don't say it, the presumption is they don't want it. They don't want the commitment. And that's fine.
What's your response to Brother Council's last point about the independent basis that he'd like us to affirm on? And is there any effect to Airboss's signed agreement to not seek further price increases?
The letter agreement is basically them saying, yes, we will comply with the obligations we already have. So what happened in that situation was they already had accepted releases, they had delivered the parts, and then they realized that they hadn't gotten the increased pricing that they had contracted for, the pass-through pricing that they had contracted for. And so they said, hey, we need to retroactively get it.
Who's they?
Airboss said to MSSC, we retroactively need to get the price adjusted on these parts that we already delivered to you. They already had a contract for those parts. And so, and MSSC complained that, well, but, you know, we now can't ask for an increase on our end because it's too late because we've already gone through that transaction. But fine, we'll do it this time. You know, we want you to tell us in advance next time when this pass-through pricing needs to be adjusted. So it's perfectly logical letter agreement, but all it does is say you're gonna abide by the prices that we've agreed to, and those agreements happen when they send a release and we agree to deliver those parts. And they can say this is not a good arrangement for us, but that's the arrangement they contracted for.
Thank you.
My time is up.
Thank you. The case will be submitted.